Good evening to you all. It's an absolute pleasure to have each one of you here. Thank you so much for coming. My name is Dr. Laura Lintott, and I'm going to be your moderator on this lovely panel tonight. I love the energy in this room already. I can feel the vibrations. I also know that there was another event just before this one, so maybe that helped. But as a lawyer, I must start with some disclaimers. Sorry, I'm in housekeeping. So, number one, tonight promises to be filled with food for body and mind. Should you become overwhelmed with the urge to throw a tomato or egg at me for raising any seemingly controversial views, please postpone your action until I give birth in about 2 weeks' time. Secondly, please beware. This event is going to be recorded, so that may result in you becoming instantly famous on YouTube overnight. And then finally, the panel discussion should last no more than an hour, after which you are welcome to join us for some food and drinks at the lovely Keating Chambers Terrace. So now, I would like to extend my deep thanks to Keating Chambers and Jade Clark and her team in particular for their unwavering support in hosting this event. Thank you also to Wiley Blackwell for publishing this book. And I apologize for my voice. I actually woke up with an ear infection, so if you want to say anything, I won't be able to hear you. You may want to speak to my co-panelists. I would also like to say thank you to our esteemed panelists for joining us tonight, to Alana Labadi for coordinating all the invites day and night before tonight, may I add, and to Demi Dighton, the very talented designer who is behind the invitations, posters, and leaflets, where you can also find the QR code should you wish to purchase an electronic or hard copy of the book on Amazon. Please note that in the hard copy, pictures are in black and white with footnotes leading to the actual colored images, whereas in the electronic copy, everything is in color. And then special thanks go to my husband, Alex Lintott, who insisted I have this book launch and who, for some reason, has decided to share his precious life with me. You see, I have a very happy marriage. Whether he has one, you have to ask him at the after drinks. There are many, many more people to be thankful to, as all achievements are the result of collective efforts. Some are listed in the book, and if I missed anyone, please feel free to post me an official howler. It's a Harry Potter reference, just saying. And now, a drum roll for our esteemed panelists. Please welcome the Earl of Lytton. John was born in 1950 in Minehead, Somerset, and brought up on Exmoor Hill Farm. He was educated at Downside School and the University of Reading College of Estate Management. His professional career encompasses decades of practicing as a chartered surveyor, initially in the public sector, then private practice. John is fellow of the Royal Institution of Chartered Surveyors. He first sat in the House of Lords in succession to his father in 1985, eventually leaving in 1999, and then returning as elected hereditary peer in 2011. John served on the Built Environment Select Committee from 2016 to 2018 and sits as crossbencher. Now, as many of you know, he famously took the Party Wall, etc. Bill, now 1996 Act, through its Lord's stages. In the past, John was president of the National Association of Local Councils and patron of Chartered Association of Building Engineers. He has an honorary doctorate from the University of West London and has had a long-standing association with First Shipley Scout Group. He is a resident of the Shipley Parish in Horsham and Deputy Lieutenant of West Sussex. John is a devoted father of 3, now adult offspring, and a husband to his native Viennese wife. His writing skills and mathematical mind are no doubt attributable to his direct ancestors, Lord Byron and Ada Lovelace. A big applause, please, for Lord Lytton. Now, please welcome Ben Mackey. It is a pleasure to have Ben Mackey with us tonight. Ben is a surveyor specializing in party wall matters, a chartered construction manager, and a founder of the Party Wall Collective. He runs the monthly Party Wall Clinic, where people can have party wall problems solved by a panel of experts, many of whom are here in the room tonight. He loves to travel and has been to some places that he never thought he would visit, including the Antarctic, the Galapagos, and South End. He asked me to tell you that he has a dodgy tattoo. I will not ask any questions on this panel on that. And has written several stories and songs. He has done gigs in Sweden and the Philippines, and he likes to play chess, apparently whilst cycling. Most importantly, Ben is a devoted father of 3 and a husband. He also has a dog, a Quaker parrot, and hamster, and many, many ants. A big round of applause for Ben Mackey. And now, please welcome Nick Brown to my left. Nick is a practicing Chartered Building Surveyor, Fellow of the RICS, Fellow of the Pyramids and Thisbe Society, member of the faculty of RICS, accredited mediator, and member of the Faculty of Party Wall Surveyors, member of the Chartered Institute of Arbitrators, and is an RICS accredited mediator and RICS trained expert witness. Since 2017, he has been one of the editors of The Whispers, Party Wall magazine, and has written a number of articles for various trade publications, including the RICS Modus. Nick owns and operates Ashridge Surveyors Limited, based in Leafy Trink, Hertfordshire, and also lectures at various higher education institutions. Now, he is an APC chairperson for the RICS to ensure professional competence for surveyors looking to become chartered, so beware. Nick asked me to say that he stresses that he is not an out-and-out party wall surveyor. Nick is a devoted father of 2 and a husband, plays the guitar, and at least 50% of his audience can work out successfully what tune he's trying to play. His talents are versatile. Apart from being a skilled musician, Nick also plays basketball twice a week and walks very slowly for the rest of the week. He loves cooking, and it's been a really long time since he gave anyone food poisoning. I believe the estimate is 3 months? Oh, big round of applause for Nick, please. And then finally, moi. As noted earlier, I'm Laura Lintott, and I'm a solicitor advocate and international arbitrator in London. My experience focuses on leading on complex international and domestic construction disputes. I'm a fellow of the Chartered Institute of Arbitrators and visiting fellow at King's College London, where I joined the Centre of Construction Law and Dispute Resolution Task Force, which responded to the Law Commission's 2 consultations regarding the Arbitration Act 1996 reforms, resulting in the Arbitration Act 2025, which received royal assent in February this year. I contributed a chapter to the book, The History of the Technology and Construction Court on its 150th anniversary, edited by Sir Peter Coulson and Dr. David Sortel, who's right now with us in this room. Hi, David.
Hello.
I am a frequent panelist and podcaster and publish regularly in numerous journals and periodicals. Now, I have been informed that I have acquired a reputation for helping to mitigate potential disputes and making use of ADR, the hot topic of tonight as well. I have advised clients on cases in the TCC and in multi-party international arbitrations. Types of work have included public infrastructure, manufacturing facilities to defects and fire safety issues in social housing. And tonight, you may think that there are 4 panelists, but you are sorely mistaken, because really there are 5, with the 5th one officially emerging in 2 weeks' time, and hopefully not tonight. But Alana, you have the 999 on speed dial. In a nutshell, I'm a passionate parent to our lovely daughter and soon-to-be emerging son, and I'm a passionate lawyer. I'm German, Austrian, Greek, Romanian, born in the former Czechoslovakia, indulge in discussions and walks, enjoy watching legal drama because it does not reflect reality at all, and discovering fresh perspectives. Oh, and I wrote the book we are talking about tonight. So, and now to our panel discussion. We will try and keep our answers to about 5 to 10 minutes each. I don't know how I'm doing so far, but I'm just going to very quickly kick off about the actual book. So I say party walls are like salt. Many of us may not consciously think about them, but most of us are affected by them. The aim is a collaborative approach with one goal in mind: to help parties in party wall disputes save emotion, time, and money. Party wall disputes can be unnecessarily costly, as you know, and time-consuming due to the lack of clear structure how to deal with them and lack of awareness of which areas of law and fact are relevant to them, as the Party Wall, etc. Act 1996 is only one piece of the entire puzzle. This can result in a negative impact on individuals, families, and companies, causing them emotional and financial hardship, particularly where parties have been neighboring landowners for decades and where breakdown of their relationship can leave one or both parties with no other choice but to sell their respective properties, possibly at a lower than market rate to expedite the sale. Where party wall disputes end up in court, this is often unnecessary and places a burden on the court system. Party wall disputes tend to be particularly painful and can often be disproportionately expensive because feelings run high and cannot be ignored. Agreement is therefore to be encouraged, for example, with the assistance of a party wall surveyor, mediator, or adjudicator. So when looking at the area of party walls, one can see there is a repetitive pattern of how party wall disputes can arise, how they may be mismanaged by not complying with the relevant legislation and failing to seek guidance from surveyors and, may I boldly add, lawyers, resulting in a negative impact on people's well-being and lives. Now, the repetitive pattern of party wall disputes, however, gives rise to a solution: systematization of recurrent issues and recognition of warning signs prior to disputes arising. This in turn gives rise to the potential for dispute prevention, if well managed, and provision of a selection of potential dispute resolution methods. The purpose of this book is to take a holistic view of party wall matters. The aim is therefore to not only analyze the Party Walls Act, but also look far beyond it, to bring together those areas of law and fact that are most relevant to and frequently encountered in party wall disputes, provide a more comprehensive understanding of party wall disputes, and help resolve such disputes in a practical and effective way. So, what does the book do? It analyzes, of course, the Party Walls Act 1996, but then it goes much further. Party wall disputes often touch on other areas of statute law that can impact on each other. For example, the Access of Neighboring Land Act 1992, the Land Registration Act 2002, or even the Human Rights Act 1998. Then we have property rights, such as rights of way, rights of support, drainage rights, or rights linked to easements, such as whether there is or is not a right or obligation to repair. Now that is the question. And tort, such as nuisance related to noise and vibration or breaches of rights to light. In addition to areas of law, there are factual matters that also need to be considered in the context of party wall disputes. And these include structural issues such as cracks in party walls, subsidence, underpinning, thickening, repairing, raising, cutting into a party wall, increasing or decreasing its height, you name it. And then there is the question, what type of dispute resolution is appropriate in what situations, including the notice procedure under the Act, litigation, or ADR. Now over to Lord Lytton. A fascinating aspect of the Party Walls Act is that it was introduced as a private member's bill in the House of Lords by yourself. Considering that private members' bills seldom materialize into actual legislation, this is a substantial achievement. So, John, please tell us, how did the Party Walls Act come about?
Right, well, Laura, firstly, thank you. Sorry. You can hear me, I hope. Sorry, Laura, thank you very much for the introduction. And you didn't get a round of applause for your having given your own credentials, but I think you ought to have had. So. Anyway, the party wall. Well, first of all, I think I should say, from my point of view, it was happenstance to use that word. It all goes back to the reforms of the political reforms that were going on at the time, and the fact that Margaret Thatcher and her government particularly disliked Mr. Ken Livingstone and the GLC. And what sat behind Ken Livingstone and the GLC, among other things, were the London Building Acts. And in the approach to abolition, the London Building Acts were going to disappear. But a number of people felt that it was the Party War Act provisions were sufficiently important and weren't replicated in any other bit of legislation to be worth salvaging. And I became involved not because I was the original peer who was going to do it, because that was going to be Lord Lucas of Crudwell. But he tapped me on the shoulder one day and he said, look, I was going to bring forward this bill, but he said, I can't now do it because I've been elevated to a junior whip, and that prevents me from dealing with this, which in a sense is not a legal prevention, it's a protocol prevention, like so many other protocols in the House of Lords. And so that was how I got involved. And I would say that I've never regarded myself as being an expert on party wars, but I could see enough of it to be a bit like that old adage that in the kingdom of the blind, the one-eyed man is king. And I felt very much that I understood enough of it that I could, because that's really how Parliament works. It's not full of experts, it's full of people who might be called as competent generalists. Some of them come with expertise, but they very often don't get to use that expertise in the House. But I had done some party war work, but I didn't regard myself then and don't regard myself now as an expert, or for that matter a particular authority. But I can see the philosophy behind it, and frankly it was not that I was, if it hadn't been the fact that I was very much supported and was standing on the shoulders of people like the late John Anstey, it wouldn't have succeeded. But that was the genesis of the thing, and because it needed salvaging, and the government recognised that it needed salvaging, it got a certain amount of tacit government support. And frankly, without government support, you don't get anywhere. So it did end up with having some government support, and the government was prepared to put its lawyers and the resources of the Department of Environment, as it was then, behind it. And there were other people in post in the DOE, like Paul Everall, who was I think may have been then the chairman of BRAC, which was looking at was the Building Regulations Advisory Committee, and he was very influential in that. But there were one or two things that we didn't get through, and some of them were mission critical. And John Anstey certainly thought they were mission critical as well, and they were potentially significant losses. You always have to be prepared to give something away in the process of trying to get these things through. The first thing was we could get no definition of a surveyor because it was considered to be contentious if we said, well, it was going to be a fully accredited member of the RICS. Well, what about all the other people that were doing it, the architects, the engineers and this sort of thing, because there were other people doing it. Bearing in mind the London Building Act came very much from a building regulatory standpoint, and so that was how it was dealt with, and it was always assumed that it was under the general oversight of London Building Control. I mean, that was how it was formulated. That was how it was dealt with under the terms of the Act. And you automatically had people who knew what they were doing. Once it became, free to air, as it were, and became a national thing, that assumption didn't hold good anymore because it could be anybody else. So the first problem was we didn't get a definition of who the surveyor was, and frankly, provided it was somebody who wasn't a party to the matter, it could be anybody from your cleaner upwards. I mean, and that was the thing, and that's been a problem, that there are people who don't understand the concept and haven't really got a handle on the technicalities, and certainly don't start with an understanding of building construction and indeed how party walls fit in the nature of land ownership and their constructional purpose. So you've got this question of ownership and you have this other question of purpose, and then there is this legal framework to try and deal with it. So that three-legged stool is very important that it stands reasonably level. And the second thing is, of course, there was no sanction for not observing it. So you had people who said, well, we don't have to worry about that. And of course, all the people that were lobbying against the bill at the time it was going through were very much the loft conversion people who didn't want to have to ask the neighbour before they punched a hole through the party wall in order to stuff a piece of steel in there. And you had all sorts of strange things going on. There were all sorts of may I say it, the lawyers weren't particularly overjoyed with the idea of the party wall bill becoming an act, because they thought that actually you'd have surveyors dealing with matters of title, and this was beginning to look a bit like a professional turf issue, so that was they lobbied quite strongly against it, but it did eventually go through, not without having had something like 110 or 115 amendments moved by me at committee to my own bill. So, but I hadn't been, and may I say that the Coherence and Dispute Club, as it was then, and the original Green Book were absolutely pivotal in getting people to understand how the whole thing works. So there was a lot of background, and they'd done a lot of preparatory work on how they would deal with it and how the thing would be improved. The difficulty was we were really lifting a piece of legislation from a London Building Act and just putting it into a general Act of Parliament. So there were very limited grounds in which what you might call the wish list of the Coherence and Dispute Club in terms of a much more radical improvement could be incorporated into that new fund. And that's still a matter of unfinished business, as those of you, who've been involved with the Coherence and Dispute Club and the Coherence and Dispute Society and what it is trying to do and what it has been trying to promote in terms of improving the Act will know much more about it than I do, because you've attended many more meetings than I have. I see Stuart giving me a sort of sly grin, because he's one of the people who knows how little I really know. So that is a sort of genesis of the thing. Have I spoken for long enough? And there is unfinished business, and of course the thing was sufficiently different to well, first of all, it was able to draw on some of the old case law, and that was a great advantage. So you've got if you like, a little attaché case full of decided cases which dealt with certain things, but of course it didn't deal with everything, and so in a sense, one of its both successes and failures, if you like, is that so few cases since have actually been to any senior court and resulted in a decision on the points of principle, which is sort of an element of success, if you like. But on the other hand, it would be nice if some of the more nitty-gritty things had got decided along the way, and they haven't necessarily been decided on the way. So I'm afraid, within the next year, 18 months, I shall be out of the House of Lords, and everybody will say, well, certainly people on the Labour Party side would say, not before time. We need to get rid of these hereditaries. But I have already done in two separate bouts 28 years in the House of Lords, and I think one has to admit that there's a limit in terms of battering away against political think tanks and wonks of one sort or another that are guiding government policy, which is about what is politically expedient, rather than the things that possibly I might think of as a now virtually retired but previously practicing chartered surveyor, namely that surely the facts and the economic and functional reality must hold some sway. Well, not if you're dealing with things in Parliament, I have to say, because some of these things exist in a sort of ether that you can't really get hold of. It's like the amoeba. You think you've got hold of one bit, and it's sort of squeezed out in another direction. A bit like making animal figures out of balloons. It's a real art and a science to work out where this is going, and it's getting worse because the degree of political elite detachment with what I would call the professional's understanding of the real world is, I think, at times quite alarming. So I just say that. So that's sort of a bit of a backcloth and a bit of looking forward. And I'll now pipe down because you've got other people who need to speak.
Thank you very much, John. I mean, one thing I would say is that it's interesting how you hinted at success and how would one define success. There are many definitions, but something I can think of right now, I see success as being part of a change, part of evolution, part of a process. Because I hope certainly that this book is not going to be a standstill point and in 300 years' time people will be still referring to it. I hope not. I think it's a point on a journey to keep improving. And I think the act, your act, is an absolutely pivotal part of this journey, and without it we would be not in a very happy place. So thank you very much for that. Now, Ben, do you consider the Party Walls Act to be effectively applied by surveyors?
So, all good? Oh, we're going to shimmy.
You need to stop. Sorry.
Shall I? Oh, here we go. Oh, there you
We
go.
have a little camera here, everybody needs to be seen.
Oh, that's great. So, I wasn't in shot just now. Oh, right. I've been out of shot.
Yes.
So, do I consider that the Party Wall Act has been effectively applied by surveyors? I did answer just straight off no. Then I spoke to Stuart just before this, and he's, should probably say a little bit of yes as well, shouldn't I? So be a bit more weighted and a bit more diplomatic. But firstly, thank you everyone for coming. And Laura, that's a great book from what I've read so far. But I am. It's going to take me about a year to get through that and fully sort of digest it, because there's it's a very different book in a good way. So it's got me thinking, and it looks at the periphery of the Act as well, and interactions with other pieces of legislation and ideas about dispute resolution, which I find really interesting. So it's going to take a while to absorb that, but I'm really enjoying it so far. So I've got a bit of imposter syndrome because there's so many people out there in the audience as well that could easily be sat here, in my place. And this morning I was looking in the mirror with a bit of self-doubt, saying, oh dear, what am I doing, on this panel? And then I had that light bulb moment. I looked at myself in the mirror and I thought, I'm ridiculously good looking. That's why I'm here. Because there's so many people here that are very talented, that could easily, be answering the question about the effectiveness of the application of the Act by surveyors. To answer no is to be critical of my fellow peers, so it's a bit, it's not that easy to say no, we're not applying the Act effectively. But if anyone's got any issues, my mum's here, so you've got to go through her. So I will go through a little bit of how we as a community are coming together, and I think it's a really good thing. We've got Pyramus and Fisby Society and the Faculty of Party Wall Surveyors, and there's a lot of good work going out there, and a lot of really good surveyors. So in this room we've got Stuart Birrell, Hannah Boyd, Andrew Schofield back there I see, some really, really good surveyors, Stephen Cornish, people that are actually working very hard to give a lot to the community to try and create a better landscape. So in terms of are we effectively applying the workings of the Act, the good work that these surveyors that I've just mentioned, the good work that they're doing, can help us all to move forward in a positive way. I'm still going to criticise the hell out of surveyors and explain why we can apply the Act more effectively, but there's a lot of good work going out there, so I don't want that my following comments to overshadow that. Very briefly, effectively is just a great word. I don't know whether it's intentional or not, but the Party Wall Act itself doesn't actually comment on the behaviour of a surveyor, except for in sections 10.6 and 10.7, it does actually refer to the behaviour of a surveyor, where a surveyor can refuse or neglect to act effectively. So that word there is the very word that governs how a surveyor, I think, should be behaving. So thinking about what effectively actually means, in the context of the Party Wall Act, effectively means to achieve a desired result. And for me, I learnt this when I was in the police, really, that we should always act proportionately. Everything should be legal, appropriate, and necessary. It's like this, what's it called, an acronym or something? Or I don't know what it's called. Anyway, it's called PLAN, so PLAN, proportionate, legal, appropriate, and necessary. So that's what all of our actions should be. And if you fall short on just one of those things, you're going down the wrong path. Yeah, so we're not actually acting effectively within the meaning of the Act. Just one of those things, right? So all four of them have to be in place. We also need to act in a timely manner. So the Party Rule Act does actually have the opportunity to do what's known as a 10-day request. And again, that is a request for a surveyor to act effectively within the meaning of the Act. So it's a very important word, the word effectively. So I think there are various areas where party rule surveyors are not effectively applying the Act. Are you right, Mother? That's all right. All right. Do you need water? I've got. All right. Behave. Right. So, in terms of the section 10(1)(a) is the very first part of the dispute resolution process, and this applies to the agreed surveyor, which is very much underused. And so, Lord Lytton, I believe you said that the agreed surveyor should be quite widely used, or it would be something to be encouraged. And I don't think it's being encouraged at all. So when I look at our industry, and if we are acting in a cost-effective manner, and are we acting proportionately, I think that there's a massive underuse of the agreed surveyor route, and this is one of my biggest issues. I think that although I don't know statistically what percentage of fees might be unnecessary, I suspect it's a lot, and that collectively, if party rule surveyors might be an industry generating, say £200 million a year, it might be the case that £50 million was unnecessarily generated by the fact that as a profession or as a community, we benefit that if there is a dispute, it's better for us collectively as the party rule community to have that dispute resolved by 2 surveyors instead of 1. So I think that we're setting it up in such a way that we are making a lot of money, quite frankly, in a way that is not to the benefit of the wider community. So there's lots of ways that this happens. There's, notice packages can be quite poor. My notice package actually offers the opportunity to for the adjoining owner to pick their own surveyor and then simply just to tick a box to say, I'm happy to share my surveyor with the building owner. Very few surveyors do that. I haven't come across a surveyor that does that. But the point is it's proactively offering the agreed surveyor route in line with what Lord Lytton suggested should be offered. There's also the pre-dispute letter of appointment where people are just serving notice and saying, well, I've got a letter of appointment here, I'm all good, and you're just setting it up for a 2-surveyor dispute, which I think is just wrong. You're not actually appointed, and you shouldn't take an appointment until there's a dispute, and there can't be a dispute until you've actually served a notice and someone's responded indicating a dispute. So the pre-dispute letter of appointment already sets it up so that there's a 2-surveyor dispute. So again, that's wrong. That's not effectively applying the Act. Surveyors are getting a bit excited. They want the money, so they're just simply going to get that letter of appointment, get the job in the bag, get the money, and so that's ineffective to the public. Then you get the telephone call, someone saying, I've got a notice from you, Mr. Mackey. What should I do? I don't know. Maybe appoint me as the agreed surveyor so I can make some money, or appoint another surveyor so we can all make money. So the point is that when it comes to giving advice, I'm quite strict on this. I don't tell people how to respond to the notice. I just say, these are your options. You choose what's good for you. So, and if that's consent or dissent, whatever. But I just tell them the difference between the options. I'm very disciplined, and that's how I think it should work. But I also know that if I had to hit targets and bonuses and I wanted a bit more money, I would easily persuade someone to say, oh, your house might fall down, If they take that chimney breast out, your house is going to collapse. You better just get me and I'll sort it all out. So, there is that sort of pushing to generate money by surveyors. So the agreed surveyor is underused, and that's a big thing. The next thing is the poor conduct of surveyors. there's so many examples to go through, and I've only got probably about 5 more minutes. So you've got the weaponisation of security for expenses, which is where you can torpedo a scheme for any reason, really. So I've come across 2 examples quite recently. One was where I challenged a surveyor on his fees, and he said, no, I don't really want to reduce my £2,500 fee for a loft extension, but I will, but I'm really annoyed. So although I got him down, we had agreed to the award, but he said, oh, by the way, I want to do a security for expenses request for £5,000. And because the work hadn't started yet, we then had to entertain that. I did manage to do a third surveyor referral based on the unreasonable behaviour of the surveyor, and I got his fee cut down probably to about 20% of what he had asked for. So it was a good result, but the point is, it was the weaponisation of security for expenses that was improper. I then also had another example where someone was taking 3 months to arrange a schedule a condition, and I said, can you hurry up, please? It's been 3 months, and someone wants to start work sometime soon. And the surveyor said, oh, I'm just going to go on holiday on Friday, but say this was a Tuesday. So I said, we've still got a few more days. Can we just get something booked for when you're back? And he goes, nah. And I said, this is really poor. So he then reported me to the faculty, and in his next email said, given your attitude so far, Mr. Mackey, I demand that we make a preliminary award for security for expenses for a loft job, which is just the weaponisation of security for expenses. So I just sent that to the faculty, and we didn't hear anything, so that was all, whatever. But the point is that if I've experienced it twice and I'm just one surveyor, I know other surveyors, I've spoken to them, they've experienced it too. So it's, effectively using the Act, but as a weapon against the public, and that's not good. Then we've got loads of ultra-virus awards going on. My most recent example is 2 surveyors awarding themselves £5,000–6,000 worth of fees because a member of the public made a complaint to the RSCS, and they spent some time dealing with it, and they wanted to claim that money back, so they made an ultra-virus award to claim that money back. It was thrown out only about 2 weeks ago by Judge Parfitt, who just said that the award made was not in pursuance of the Act. There was no costs incurred, so it was an ultra-virus award. So that's fine, but the fact that they even tried that was outrageous. You get the 10-day requests to act effectively at Christmas time. I've had that on Christmas Eve. That was fun. There's a surveyor who uses a fake name. There's a surveyor who says he's a Rick's Party Wall surveyor in his email, but he's not. I've had another surveyor in the last couple of weeks give me a letter of appointment. We do the award, and then it's only a chimney breast removal, and then I say to I chase up the building owner for my fee, and the building owner's like, I never instructed anyone to do anything. And I said, well, what about this letter of appointment I've got with your signature? That's not my signature. What do you do about that? You can't tell me that the Act is being administered effectively by party wall surveyors when we've got this behaviour. The surveyor in question is unregulated. He's not chartered. He's not a member of P&T or the faculty. So what can I actually do? There's nothing. It's immunity. Surveyors are not immune from suit. The case of Crowley versus Russell Gray is often, I think, misquoted, and Edward Bailey would agree with me there that we should act as if we can be sued. But the reality is that there is a level of immunity based on the reality of the situation, which is that it costs a hell of a lot of money to sue someone. I will start to wrap it up. I could go on forever, But I know that Lord Lytton said that there's so few cases that are being brought about, which is a sign of success of the Party Wall Act, and possibly a sign of success in terms of how surveyors administer the Act. I would have to respectfully disagree with that on the basis that it's very costly to bring about action, right? And if you look at some of the cases, they're just millionaires having fun. That's it. If you look at some of the cases and what they're about, some cases involve multiple, there's 3 or 4 cases attributable to 1 or 2 millionaires, for example. So access to justice is for the rich, and that's quite a sign of why the party will act, why there's so few appeals, in my opinion. It's not to do with the good behaviour of surveyors, because I'm on the ground, I'm seeing it every day, the bad behaviour, and it's quite harsh out there. So I don't think it is being effectively applied in general, but I also think there's lots of good people out there who are trying their best to change and improve the landscape, and for that they've got all my support.
Thank you very much, Ben. I always like to hear about bad behavior as a litigator. And without it, there wouldn't be much to talk about. Thank you very much for that. I'm going to now talk about something slightly different, and that is, when can alternative dispute resolution help in the context of party-wall disputes? And there's a separate chapter in the book on this as well. So, although the complexity of party-wall disputes is addressed in this book, the simple and most common reason as to why party-wall disputes arise is often the basic right, need, and emotion behind preserving the landowner's or occupier's territory, and to not negatively impact on the adjoining land. That's very simplified, but it lies at the crux of the problem. This book advocates for a pragmatic, cost and time-effective dispute resolution approach out of court, where possible, considering the common disproportionality between the value in dispute and cost or time connected to litigation. This book also presents dispute management and resolution options, including a strategy analysis to be applied prior to a dispute arising. Pardon me. So, in an ideal world, and as we all know in this room, parties to party-wall disputes would adhere to the statutory provisions of the Party Walls Act, whereby the building owner serves the appropriate party-wall notice before both the building owner and the enjoining owner can enjoy the rights conferred by the Party Walls Act. Now, the advantage is then that the parties can benefit from one of the main purposes of the Act, namely resolving their party-wall dispute, if one arises, under the Act outside of court. Should a dispute arise, parties would appoint a party-wall surveyor or surveyors to render an award, hopefully resolving such a dispute. So that's in an ideal world. While such an award can be appealed in court, parties still have the option to agree to try and negotiate a settlement by way of alternative dispute resolution, for example through mediation, which is my favorite personally. And in such a case, parties would agree to suspend court proceedings, and if they agree on a settlement, court proceedings can be formally brought to an end. However, the option of ADR is open at any point in time prior to as well as during court proceedings. And I would like you to hold that thought in mind. The parties even have the possibility by agreement to ensure that the dispute resolution procedure in Section 10 of the Act is not engaged and pursue a form of ADR instead of the mechanism prescribed under the Act. I know that what I said just now will raise some eyebrows, but let me just elaborate on it in a second. And there's a full wording on this with precedent law in the book as well. So where the building owner fails to serve, so the building owner now fails to serve an appropriate party-wall notice, the Act will not apply. This is again where ADR as an alternative to litigation is a desirable way forward, as it can preserve or repair relationships between landowners who are in party-wall disputes. So in a nutshell, ADR is relevant to party-wall disputes where 1. A building owner failed to issue the relevant notice and so the Act does not apply. 2. A party-wall award has been appealed in court, so you are already in court. Do you really want to get through with it, or do you maybe want to settle? Parties may change their minds and think this is not worth it. As in the court process, it's not worth it, let's try and settle outside. And then number 3, where parties agree to not engage the dispute resolution procedure under the Act. So one of the elephant questions in the room is whether parties can actually opt out of the Party Walls Act. And the short answer is no. It is a statute that does not permit to opt out of it as such. However, there is a decent amount of precedent law in place confirming that it is possible that the parties, i.e. the building owners and adjoining owners, by agreement can assure that the dispute resolution procedure in Section 10 is not engaged. The Act contains no provision preventing such an agreement. So please refer to Chapter 4. I'm sorry, I'm using it as a bait a little bit, I suppose, but I hope you enjoy. In the book, I discuss the protocol, the notice procedure under the Act, litigation, the option to apply the Party Walls Act dispute resolution mechanism voluntarily by agreement where the building owner failed to issue the relevant notice, and ADR, which includes arbitration, MEDI-ARB, early neutral evaluation, expert determination, and my favorite, mediation, which is swifter and cheaper than litigation and can be done at any point in time. So bear in mind that courts support ADR where it can avoid or stop litigation, and refusing to participate in ADR without reasonable justification, therefore opting for litigation, can result in court-imposed negative cost consequences for the uncooperative party as an issue of conduct. When trying to settle, parties can mark relevant correspondence without prejudice or without prejudice save as to costs, and a section of my book explains why that may be beneficial to everyone involved, to all parties, because they can then have certain discussions that are confidential. I do have a little bit here more on strategy, but I'm just aware we are running out of time, and we have another wonderful panelist, Nick Brown, who I think has a lot to say and a very interesting perspectives on this topic as well. So, Nick, I'm going to ask you, how would you compare the roles of mediator and party wall surveyor to each other?
Thank you very much. I'm just going to say hello to the people in the cheap seats over here who haven't been able to see me all day. Poor you. So I'm going to tenuously kind of link the two, but when Laura very kindly introduced me to her book and asked me to come and talk this evening, I didn't perhaps clock that I was going to be coming to Keating Chambers and talking to such luminary legal professionals. So a lot of my talk has actually gone out the window, but I have still clocked that I can get to that door in about 20 seconds if I need to. So with both mediation and party wall surveying, your aim should really be to kind of resolve a dispute. And obviously with the Party Wall Act, you're trying to allow one side to proceed with their works whilst protecting the other side. And with both, and I think Mr. Mackey might have a slightly different view on this, but with both mediation and party wall, the idea is that you're trying to be as impartial as possible. I get in some instances under party wall you advocate for your owner, but you're trying to reach this impartial agreement between the two parties. And it's for those two parties to actually come to that agreement. And I always find it absolutely staggering when I get third surveyor referrals where you've got two surveyors who basically want to make themselves part of that dispute, and they will further dispute or create a dispute that just doesn't need to be there. So again, touching on what Ben just said just now, that does come down to surveyor behaviour, and it's not for us as party wall surveyors to become part of the dispute. And I've seen it where language between two surveyors becomes very impolite, unprofessional, rude, whatever way you want to look at it, and it does stagger me. Why are you furthering this dispute? Many of the phone calls I get when I'm taking on a party wall case, the amount of people that also say to me that, can I just tell you a bit about this background? Can I just tell you about this bit of history between us? Okay, yeah. And then I hear about the fact that they pull out their bins at 6 a.m. and it's the wrong colour bins. And then, you just hear about the fact that this person just get wound up by their neighbours. So, you say, right, and you've received party wall notices, right? So already you kind of get this impression that perhaps one of that adjoining owner is not going to make the building owner's life easy, and you do get this weaponisation of the act that, as I say, that Ben raised. And I think at that stage, where as a mediator and a party wall surveyor, when I'm hearing those things, it's at that stage where you start thinking, maybe this is ripe for mediation before you actually do anything to do with the party wall. Maybe you just try and mediate this dispute. Maybe there's something here whereby you don't actually take this forward. Again, as I say, I'll cut out huge sections of this because I was being very rude about solicitors. The Act is fairly straightforward in my opinion. It's the people and egos involved that often make it very difficult. And I think there's some people that certainly on a kind of adjoining owners, building owners, that they're happy to go to litigation. They want to take their neighbours to court. They want to push this forward. But getting mediation, one of the mediator's tools is that kind of, trying to push forward a level of empathy. And, can you put yourself in that person's shoes? And quite often an adjoining owner will tell me about the way that they feel about something. And it's just that, they will say something like, well, they felt like, I felt like I was being talked down to, or I felt this, I felt that. And sometimes I'll just say, it's nothing to do with the Party Wall Act, but I'll just say, have you told them? Have you actually voiced this? Have you actually told them how you feel? And the amount of people that say no. and they just say, no, I haven't, I've not voiced it with them. Well, why don't you? Why don't you just tell them that actually you feel that you're kind of being belittled by them or they're being talked down to? And that, again, that's in the mediator's toolkits, it's just asking their permission to share that information. Well, can I share that with that person? And, that I think, whether a party wall surveyor intentionally does it or otherwise, you kind of start taking on this kind of role of a mediator. Because if I shared everything that someone said to me about somebody, and I just said to that neighbour or the building owner, do you know what the adjoining owner says? You're an absolute, and then whatever word was used. It's just not going to, it's creating that dispute. I'm furthering a dispute. I'm not resolving that dispute. And again, another tool in the mediator's toolkit is that reality check. I want to take my neighbour to court. Okay, what does your day in court look like? What does that look like for you? What do you think your chances of success are? And I asked Mr. Hearsome earlier on, very kindly, and he said that you would say perhaps 80% is your best chance on the day, because 20% you don't know what's going to happen on your day in court. Whereas of mediation, the centre of CEDAR, apologies, it's gone out of my head, 2024 said that globally mediation was 90% successful. So you've got 80% versus 90%, and what does that period of time look like when you're waiting for your case to come up? What's the cost like there? What is the level of stress that you have? And when I think that something is right for mediation, right up front, when I'm onboarding some information, I'll often say to people that I think you should seek further legal advice, but you may wish to consider mediation. How long have I got?
Please go ahead.
Yeah, fantastic. I'll end on a song. I think as party wall surveyors, we should be listening for those telltale signs at the initial onboarding. When we are receiving those phone calls, looking for the bits and pieces whereby, there's already a dispute here. Before there's even, a party wall matter that might raise, and you'll get a phone call from someone saying, well, my neighbour's got this planning application in, and I don't want them to do it, and I want you to make their life as difficult as possible. And I'm just, no. It's actually, let me just explain the act to you. Let me just explain what my role is in all of this. And the likelihood of that person then appointing me is probably slim to negligible, because I'm not going to forward their dispute. I'm not going to take that on board. I am not going to make myself part of that process, unless I can see a way of resolving it. I did speak to His Honour, I'm going to keep calling him Judge Bailey beforehand, and I'm aware that there's a party wall mediation scheme. The success of this, or the numbers coming forward for this, I actually am unaware of, and if you want to understand a bit more about that, then I suggest collaring His Honour at the end. But I mean, that's something that I think that is a way forward. Mediation is, I think, a really effective way of dispute resolution. Is that all right? Thank you.
Thank you so much, and I completely agree. I would say, don't be afraid to do things differently, to take a different direction, to not just carry on in what you've been told and what you've learned in the past. But obviously, we learn from the past, and it's very valuable. But it's also a platform, an opportunity that once we get to a point where we are more experienced, we can actually take different decisions how we are going to take it forward. And the times change as well. Now, what you essentially described, your attitude is that of a truly good human being. In my personal experience, whether it's party walls or any type of heated discussion or conflict or just personal pain, is that it's very easy to withdraw into artificial or actual isolation and then blow up the problem in a way, I'm not saying out of proportion, but focus only on 1 ounce thought process and hardship. And it gets to a point where one completely squeezes out of one's mind that the other person may have a reason why they're acting that way. It may not be entirely rational, but there will be some reason, and emotion is not something to be entirely discarded. I think it's important because it forms part of human dignity, and quite often, in my view, it's a signal that dignity or something has been harmed. So it's always important to try and look at things from the other perspectives, because like you said, if I'm annoyed at someone and then let's say they didn't come to something, or they were an hour late, which one would deem unacceptable, and I don't let them speak, then I won't learn that actually they fell over and they had to go back and change their suit because they fell into a puddle, but they cared so much about me that they still made it and they didn't give up on the meeting, etc. So anyway, I'm digressing, but thank you very much for that. I would like to now invite the panel for a little discussion amongst ourselves, and the audience can participate as well. The Act has been around for over a quarter of a century, I would say nearly 30 years, and at the time of the publication of this book. And while the Act was a positive step forward in relation to party law disputes, in particular, legislative and policy improvements should continue to be made to save public money. And I say that in relation to any legislation. So if legislation or policy were to be updated, what improvements could be made in the future? Can we start with you, John, without putting you on the spot?
Well, first of all, yes. There are lots of improvements that could be made because, of course, as I said earlier on, this was lifted out of the London Building Acts and didn't get the opportunity of being a proper reform of the system. It was simply a transplant, if you like. That's one of the basic failings of that. I mean, clearly, having proficiency and clear, transparent proficiency among those who are practitioners is important. There's one thing that I think comes before the principle of the agreed survey, or indeed before mediation, and that is that it is always it was always a question that I asked when people approached me on a party wall matter. I said, do you need to dispute this particular set of works that are going on? You know, if now the boot was on the other foot and it was you doing it, would you consider it proportionate to dispute that? If you don't consider it proportionate to dispute that, why don't you just say, I agree, but subject to the conditions over leaf, and it shall be, you know, professionally overseen by somebody, that I should be provided with the necessary documentation, and that I reserve my rights under Section 10 to implement the dispute procedure in the event that there is a subsequent disagreement, or you don't do things in accordance with what you say. And lots of people were sort of happy to do that, and it was sort of coupled with the imperative that was the other question. You know, your neighbour actually might be your most valuable asset, because it might feed your cat and water your plants while you're away on holiday. You know, the neighbour you will have to live with when all the surveyors have been and done and caused mayhem, no doubt, on the way, and you are left with the same neighbour. You need to live with them. You don't need to live with the surveyors. So do think about, you know, what's happening in because, you know, there's a human dimension here. It's not just a property. It's not just a, you know, war between the two, but there's actually a whole relationship that goes on. And so many people would say to me, well, it's, you know, we used to get on so well with the neighbours and did go on holiday together, and now we can't even sort of speak to each other. And that's really, you know, where the sort of the mediation comes in. So, you know, surveyors can do a very good job at sort of helping to bury hatchets on all this, because very usually like boundary disputes in these things, the cost of sorting them out is in a very substantial inverse proportion than the economic and commercial value of what's at stake. And I think one really has to take a reality check on these things. But, you know, there are other things. I think it would be nice if there was some sort of when the construction side also needs to recognise this. I mean, how many people have come across doing, you know, where there's been a large basement construction next door, and the contractor says this, that, and the other, but actually is so careless that he doesn't really worry about whether he's stuck a load of cement, concrete, the wrong side of the party divide, because he couldn't be bothered to shutter the thing up properly, and therefore when the next door neighbour is doing their work, they've got to spend tens of thousands of pounds cutting off bits of concrete without really knowing whether they're causing much more serious damage to what's been put in. This particularly happens when there's extending a party wall downwards, for basement construction, and that's a real problem, getting contractors to understand their obligations and making sure that their specification actually matches what is necessary under the Act. So I'd like to do that. I also think that there ought to be a better collation of passing on the information to successive owners about what's happened. And the final bit that I think is important is there needs to be better education of people like government departments, and I know His Honour Judge Edward Bailey knows about this, as do some other of you, because under the HS2 legislation, the government decided to substantially disapply the provisions of the 1996 Party Wall, etc. Act. They didn't really, and this was in order to facilitate things, and what they were trying to put in place, what they did put in place, was effectively a sort of construction arbitration solution in order to try and deal with it. Any of you know anything about construction arbitration? This is the sort of nightmare scenario. Constructors love arbitration. Certainly their lawyers seem to, but I mean the constructors quite like this. They like getting stuck into this sort of stuff. And of course, you've got HS2, but the reality was that they really didn't know what they were doing, because they'd actually disapplied just about everything, including the initial notice facility. And if you disapply the notice facility, how does the rest of the Act apply at all? And that was the thing that seemed to have escaped the government laws. But we set up under the RICS oversight a little committee to sort of look at this, and we couldn't get any sense out of the there were two departments were dealing with it. It was the Treasury and the Department of Transport basically handling this thing, and they just don't get to see eye to eye. So there's a real problem about educating people like government departments and this sort of thing, because as I say, they're full of policy think tanks and stuff like that. They don't really understand the detail of what they're dealing with, and they can cause absolute mayhem. Well, thank goodness at the moment it's only limited to HS2. There was something on Crossrail which was a disapplication, but there was an alternative voluntarily put in place which actually I think worked tolerably well and dealt with, so there was an equivalent. With HS2 there was no equivalent. It was just basically they were trashing the whole thing. So there's a problem there about getting the message across as to why this matters, why there needs to be the public interest overlay needs to recognise what this whole issue of common features as between ownerships actually means, and to somehow come to terms with that, because it wouldn't have made the slightest bit of difference to the outcome of the HS2, but would have and I'm not suggesting that the absence of observing the Party Wall Act has been the cause of HS2's substantial demise. That would be too big a claim to make for it. But it could come back again. There could be other disapplications.
That's right, thank you, John. And it actually also underlines further that there are. I actually it reminds me, I got a question from someone in the past and said, well, if I comply with these legislative provisions under this Act, then surely that should protect me. And I said, no, not necessarily. It does not mean that you don't have to abide by the other legislation. Then you get into a conundrum where lay people will not know what other pieces of legislation to comply with, and this is one of the very, very good examples. And again, me as a lawyer, I'm afraid I have to say, do take legal advice. I would say also, as party wall surveyors, don't be afraid to take legal advice. I personally do not see lawyers and party wall surveyors as competitors at all. I think both of them have a very, very important role, and I think they could do a lot of improvement by talking to each other and taking advice from each other. Ben, what about you? What are your suggestions? How can we further build on the current Act going forward?
I actually wrote a draft amendment to the Act, if that's okay. But I'll just read it out, but it's only a small section, like a suggestion, which was to create a section called the cessation of work where no notice has been served, right? And it would work like this, just roughly. I just wrote it on the train, so hopefully it might not be of the highest quality. But 1, where a building owner undertakes work in pursuance of this Act without having served a notice under sections 1, 3 or 6, the adjoining owner may serve a notice to cease work upon the building owner. 2, a notice to cease work shall A, be in writing, B, state the grounds upon which the adjoining owner believes the work is in contravention of the Act due to the absence of prior notice, and C, require the immediate cessation of all work undertaken in pursuance of the Act. 3, upon receipt of a notice to cease work, the building owner shall cease all work to which the notice relates, and no further work may continue until an award has been made in accordance with Section 10, settling any disputes relating to the works. 4, any continuation of work by the building owner in contravention of subsection 3 shall be treated as a breach of statutory duty. And then I'll toughen up the offences and penalties in relation to this specific clause that I've just added. So it would be the offence of continuing unlawful works. 1, a building owner who, having been served a notice to cease work under section wherever it's inserted, fails to comply with the requirement to cease work, commits an offence. 2, a person guilty of an offence under this section is liable to, let's just say, a summary conviction, an unlimited fine, or we could say maybe death by being broken at the wheel, something like that, just giving the Act a bit of teeth. So, so cessation of work.
But Ben, you can't start off by saying a building owner who does work in pursuance of the Act, because ex hypothesi, it's not in pursuance of the Act. So you must change that draft right from the beginning, because as drafted, it's nonsense.
So a building owner is desirous of undertaking work under the Act, so desirous is future tense. Okay. So therefore, if any work is undertaken in pursuance of the Act, instead of just saying, oh, I know, you need loads of money, so you need to go to court, the adjoining owner could potentially invoke the Act by serving a notice to cease work. That's just a proposal, where I will get shredded, I get it.
I'm with you. You need to have a procedure which allows an adjoining owner to get in on the Act. That's
Yeah.
But you've got to be very careful how you draft it.
No, I know. I mean, the death was going a bit far, and the wording as well. I mean, I'm just a surveyor, so it's like
the biggest lacuna of the Act. There's no way for an adjoining owner to get involved in the Act, and even just see how badly it's drafted. I mean, no disrespect to Lord Lytton, but a Section 7.2 makes it entitles an adjoining occupier to claim compensation. But there's no way an adjoining occupier can get involved in the Act at all. I mean, it does need a lot of work. And
it's very complicated.
As soon as you use in pursuance of the Act, then you've got to rethink it.
Sorry to interrupt.
Can I?
It's a very important aspect.
Can I aid the parliamentary draftsman and say that this might be something to which the Act, the works are of the nature which would have fallen underneath the provisions of this Act, but that notice hasn't been served. The only thing I would say about the question of the fine and sanction, the late John Anstey would have said, yay, I'll have some of that, because that was one of the things that there was originally a sanction under the London Building Acts. And that was lost because the department's lawyers, the Treasury solicitor lawyer was advising, said, no, you can't have an offence under what is effectively a civil matter. And that was because it had gone from being London Building Acts, therefore, if you like, falling underneath that sort of statute, in which there were sanctions for getting a building wrong, into something that was effectively a private general act of Parliament. So the sanction would never pass muster under this thing unless it was incorporated, I think, into some other statutory provision containing those sort of sanctions. And I think it would have to have that bit of laundering, if you like, in order to put in place what you have in mind.
Thank you very much. And talking of laundering, I think the beauty of drafting legislation is that you have a team of people to do that. So in the end of the day, it will be laundered again and again and again through some beautiful minds. Stuart, did you want to say anything?
I was going to say that, I mean, John really hit the nail on the head. It was part of the London Building Acts, and it's come out. We are never going to get parliamentary time to change this act. We've been trying for years and years and years. And even if we got it, we'll correct what we think needs correcting. In another 5 years, other things will happen. It needs correcting again. Surely what needs to happen is to get rid of the Party Wall Act and put it back into the building regs. Then every time the building regs are updated, changed, you've got the opportunity to look at it again.
Thank you. So I think slowly we are coming to the end of this discussion. I just wanted to put Nick a little bit on the spot. I asked him, shall I ask you a question? And he was very polite. And I am terrible at reading signals due to English politeness. So I'm going to give him an opportunity. Is there anything else you would like to add to this? Or I'm sure we can discuss this for hours, or we can have wine. Well, I can't, but you can.
I mean, after watching what just happened to Ben, no. I think I'm just going to go out with maybe capping or guidance around surveyors' fees. There we go. That's a nice popular one there.
Oh, I like that. I like that. I'm going to throw a couple of suggestions myself, that is potentially a retrospective effect in relation to the relevant notice, because I think on one hand you can have a building owner who's scheming and plotting to not issue the relevant notice, thinking they can get away with it. But I genuinely believe you can also have building owners who just don't have a clue. And then they learn about it too late, and then what then? And of course you can untangle it, but I think the legislation could address this in a more collaborative or explicit way. I also think that there could be a checklist, which is not per se in relation to the legislation itself, but it could be appended to the TCC, to the Technology and Construction Code Guide or Practice Direction, just for members of the public to go through that checklist, to know what to cover off, what questions to ask, what considerations to think about when a party will dispute is about to emerge. And then finally, penalisation. So I already touched on the building owner being naughty or not being naughty, but making a mistake. I think some penalisation should be brought in, but I also think it should be under certain conditions, so that a building owner who genuinely made a mistake can rectify it. But I do think that to have something in place would help. These are just suggestions. I'm not saying they are right or wrong or the only way. Again, there's a little bit more in it on the book, and I'm sure much more on it in your minds. So all I'm going to say as a conclusion, working on this book has motivated me to collaborate with many of you, with very talented lawyers, party wall surveyors, judges, and it's been a real pleasure and eye-opener. And I have been fortunate to get embroiled into very interesting and vibrant discussions. So I would encourage for the readers of this book to continue going with time and keep developing solutions that can help those in difficult situations to prevent, mitigate, settle, or manage any party wall disputes they find themselves in. The evolution of the law cannot be stopped. I heard someone telling me, but the law is given, it's set in stone. I can guarantee you it is not. It is fascinating to watch its transformations and extremely rewarding to be part of the process when it takes a positive turn for once. This book recognizes the importance and value of both lawyers and party wall surveyors, like I said before, and what they bring to the table, and embraces cooperation between the two professions, which is in the best interest of the clients who need our help. So I want to say thank you all for coming tonight. It really means a lot that each of you made it. I know who you are, obviously. I've got you on my list, on Alana's list. Sorry, and now join us for some nibbles and wine and drinks and a wonderful view of London from the Keating Chambers Enchanting Terrace on floor 6. Just take the lift so when you come out and join us. Thank you so much.
Can I just say congratulations to Laura on the addition to the family that's about to happen, but also most particularly on the book, because I think it's just it does expand the horizons of and the context in which party wall surveyors have to deal with it. And I think, you know, one of the next horizons is going to be, what do we mean by the extent of private ownership in an increasingly urban environment, when actually there are societal shared matters, there are community shared matters. That is going to be the next frontier, because that is fundamental to what we mean by, you know, increasing urban density. And unless we're going to go on adding things into the countryside and building new towns all over the place with all those extended supply lines of roads and services and Uncle Tom Cobley and all, we need to understand that urbanisation is going to remain a substantial factor, and making best use of the expensive infrastructure that's already been put in place. So I think that's one of the that'll be for the next volume somewhere around.
Well, in the end, the future will bring only party walls and nothing else, because there will be no countryside in a few hundreds times. But thank you. If you have any questions, by all ask. But I suggest we do it with a drink in our hand. So in my case, orange juice. Thank you.
Thank you, Laura.